conclude with the law department, we would like to, well, not conclude because we still have the LLMs, but we want to award the prizes in the law department, and I would like to invite Giorgio Monti to present the winner of the Mauro Cappelletti Prize.
Mauro Cappelletti, in whose name is honored by this prize, was a distinguished and innovative scholar who bridged the two worlds of European and American law and has influenced a whole generation of scholars in both continents. He was a professor of law here at the EUI, at the University of Florence, and at Stanford University in California. His publications were devoted to the comparative analysis of legal institutions that were necessary for democracy and European integration. His work on comparative integration was and still is highly influential. His books on constitutional courts and access to justice continue to be widely used. One of the alumni of the EUI and a former student of the late Professor Cappelletti, Robert Helm, generously continues to finance the annual award of this prize for the best doctoral thesis in the EUI in the field of comparative law. This year, the Law Department proposes that the prize should be awarded to the doctoral thesis by Michal Bobek in his thesis entitled Comparative Reasoning in European Supreme Courts, a study in foreign persuasive authority. Michal's thesis epitomizes the aims of the prize and is a fitting tribute to the scholarship of Mauro Cappelletti. Not only is it comparative in itself, in examining 5 jurisdictions with very different legal traditions, it is also a study of the use of comparative sources in the legal process. In the words of one of the external jury members, the topic of this thesis is of great importance, but it has not been the subject of sustained theorizing or empirical analysis. Michal Bobek's thesis has filled this gap admirably, undertaking original research on practices in 5 national systems. The thesis is elegantly written, broad in ambition and scope, and it is full of penetrating insights from which I learned a great deal. In summary, this thesis deals with the use of comparative arguments as persuasive authority in judicial decision-making at the level of national supreme jurisdictions. The study has 2 elements, an empirical and a theoretical one. The empirical research assesses the practice of the supreme jurisdictions of the Czech Republic, Slovakia, Germany, France, and England in relation to the quantitative aspects of the use of comparative arguments in their decision-making. The theoretical element comprises 2 levels. Firstly, the level of the national legal system studied, where mainstream doctrinal views concerning the role and the legitimacy of comparative reasoning by court is analyzed. Secondly, the national theoretical approaches which serve as the starting point to determine the common denominator for an approach to comparative reasoning by the courts. The national theories and practices are used comparatively to discuss the following: issues of authority and the display in judicial decisions, the reasons for which even state-centered national mainstream doctrine accepts the use of extra-systemic arguments, including comparative inspiration, domestic legitimacy of the use of comparative arguments, the reasons for the citation or the intentional silence with respect to foreign means of interpretation, the methods of judicial comparison, and finally, against this background, the aims and purposes of judicial use of foreign authority are freshly reassessed. As well as this being an excellent thesis, it meets the criteria for the prize both in letter and in spirit, and I'm happy to present the Mauro Cappelletti Prize in Comparative Law to Michal Bobek.
The second prize for a law thesis is the Jacqueline Suter Prize, and I would like to invite Bruno de Witt to present the winner of this prize.
I will also, if I may, say a few words about the prize first and then about the winner. The Jacqueline Suter Prize was first awarded in 2009 and is given for an excellent thesis on a topic of EU law defended at the EUI, in this case during the period 2009 to 2011. This prize is sponsored on a personal basis by the friends and colleagues at the European Court of Justice of the late Dr. Jacqueline Suter, who was one of the first British researchers to take her PhD here in the law department in 1985, under the supervision of Professor Klaus Haupt, on the topic of insider dealing. She died in 2009, and Jackie worked for many years as a head of division at the Court of Justice. And it's the wish of those who knew her there in Luxembourg, her colleagues, that her name should be commemorated here at the EUI, in which she always remained very fondly attached. Ms. Sabine Hackspiel, head of division in the Court of Justice, and Professor René Barends, who is now a judge at the Court for Staff Cases, the European Court for Staff Cases, have been instrumental both in organizing and awarding this prize in collaboration with the law department here. But the prize is, of course, a personal initiative. It is not a prize attributed or awarded by the European Court itself. Now, this year, the prize to be awarded is given to Sascha Gerben for her thesis entitled Harmonization by Stealth, the Bologna Process and European Higher Education Law. The thesis discusses something with which many of us are familiar, the Bologna Process, which is aiming at establishing a European higher education area, most specifically by introducing a common system for the recognition of degrees of higher education. This process is based on a non-binding Bologna Declaration and a follow-up process consisting of regular ministerial conferences. In this sense, the Bologna process is an intergovernmental process that takes place outside the institutional framework of the European Union. This exclusion of the European Union is remarkable, especially considering the large overlap between the subject matter, higher education, of the Bologna process and the activities of the European Union, which also often deal with higher education. In this way, one could argue, and it has been argued in the thesis, Bologna detracts from the large body of EU higher education law and from the legal competence of the European Union. And therefore, from a European law perspective, there are several grave concerns about the way the Bologna process was created and how it is currently operated. It was argued in the thesis by Sascha Gerben that with the Bologna process, the member states have chosen to harmonize their higher education system, but in a way which is less accountable, less transparent, less democratic, and less effective than if they would have acted inside the European Union. I will now quote a few words from one of the judges for the prize. I quote, "This is an outstanding thesis, one of the rare publications in which a full legal analysis is presented of the Bologna process and its relation to EU law. It fills a long-standing gap. Gerben's analysis of the exclusion by the member states of any EU activity relating to higher education, but allowing for a similar result through intergovernmental measures, is also very useful as a methodology for the examination of similar processes in the field of social policy, sports law, energy, and I could add also the rescue of the euro." I fully concur with those words of the judges of the prize, and personally I'm happy to add that having been the supervisor of Sascha's thesis, this was a very smooth and enjoyable process also for me.